The Internationalization of Capital and the International State System by Picciotto or Picciotto. This is from the State Debate volume that was edited by SImon Clarke, featuring members from the Conference of Socialist Economists. I think these papers were originally in Capital and Class, but I'm not sure. The purpose of this paper is to try to renew the debate about the interrelationship of the internationalization of capital and changes in the capitalist state system. It is now over 100 years since Robin Murray pointed to the growing, quote, territorial non-coincidence, end quote, between an increasingly interdependent international economic system and the traditional capitalist or socialist nation-state. Robin Murray based himself on the then-nascent research on multinational corporations, which proved a growth industry in the 1970s and even spawned its very own UN specialized agency, the Commission on Transnational Corporations. Paralleling the famous remark by Kindleberger, quote, "The national state is just about through as an economic unit," end quote, Kindleberger. Murray posed the question, quote, whether national capitalist states will continue to be the primary structures within the international economic system, or whether the expanded territorial range of capitalist production will require the parallel expansion of coordinated state functions, end quote. He received a rapid, perhaps over-hasty reply from Bill Warren, who, as well as making some good points about some of the limitations of Murray's theoretical and empirical treatment of the internationalization of capital, was rash enough to prophesy that since the contradictions between capital and the state are essentially non-antagonistic, new international regulatory measures would quickly be forthcoming. Quote, "The tax authorities are rapidly getting control of the internal transfer price problem, and it is clearly not going to be long before the central bankers, international organizations, and state policy-making bodies chain down the euro-dollar monster so that it is no longer available to do the bidding of the large firms," end quote. Warren. Murray's provocative question sparked a considerable amount of subsequent analysis and discussion, both on the nature and the implications of the internationalization of capital as well as the theory of capital and the state. It was readily apparent that Murray's essentially structural functionalist view of the relationship between capital and the state was responsible for the starkness of the alternative he posed. Either capital would outgrow the nation-state and lay the necessary basis for new coordinated interstate or supranational state structures, or its growth would be contained within the boundaries of existing or merged nation-states. Nevertheless, much of his work on multinationals has been seminal, and his raising of the question of territoriality has not been followed up adequately. Subsequent debates have emphasized that there is a contradictory process in which the national state is increasingly involved in intervention to ensure the social and economic processes of expanded reproduction of capital. Yet at the same time, these processes are increasingly transcending the national state. The internationalization not only of the circuits of commodity capital and money capital, but also productive capital, is creating an increasingly internationally integrated world economy and social structure. However, this does not take place as a smooth process of symmetrical interpenetration of capitals to be followed eventually by a merging of social patterns and political superstructures. The internationalization of production itself entails an internationalized socialization of productive labor, as well as new international patterns of commodity circulation, both of which are as much social as economic processes. These processes entail developing patterns of international class formation and conflict which must be analyzed. These developments and the specific forms they take often owe as much to ideological, legal, and even military interventions by states and through international state structures as they do to technological or economic factors. For instance, as I have discussed elsewhere, the specific way in which the United States antitrust law was interpreted and enforced after 1940 played a major part in shaping the characteristic form of U.S. multinational capital using wholly owned foreign subsidiaries. Thus, the state has been a contributor to the process of internationalization and shaping the form internationalization takes, as well as being affected by internationalization. In Europe, where the international state system originated, and which has also been the impetus for many of the international state system's subsequent transformations, the development of the European community involves new and unique processes for interstate integration, yet the national states still play a vital role. Interstate conflicts continue, and the creation of a single unified superstate is not envisaged even by the most dedicated Europeanist. Yet the impulse to European integration has been as much political as economic. To summarize, the changes in the international system involve a contradictory and conflictual process of internationalization, both of capital and of the state. And the crisis of international capital is also a crisis of the international state system. State sovereignty and jurisdiction. In another paper, Picciotto, 1983, on which much of the present paper is based, I have examined the recent and growing problems of jurisdictional definition and conflicts between the main capitalist states, especially the United States and Europe. Specific and well-publicized conflicts have taken place over quite contentious political issues, such as the U.S. embargo over the Soviet gas pipeline and the policies to be adopted over technological embargoes to the Soviet bloc, as well as a plethora of politico-economic cases where U.S. antitrust laws have been applied, e.g. to shipping and airline cartels, in ways damaging to the interest of other capitalist states. The application of U.S. economic sanctions against Iran during the hostage crisis through the freeze of Iranian holdings in the Eurodollar system also raised serious issues about political controls over international financial markets, although the U.S.'s allies discreetly avoided creating a conflict over this while the hostage crisis was continuing. Underlying all these specific conflicts has been the general issue of increasing overlap and conflicts of jurisdiction to regulate capital. It is not surprising that jurisdictional conflicts have occurred mainly between the most powerful states and in relation to economic regulation, for it is through such forms of regulation that the main capitalist states have been involved in shaping the patterns of internationalization of capital. These assertions of national state power in relation to the structuring of international capital and the attempts at accommodating the conflicts of jurisdiction that have ensued have been in many ways more important than the other more prominent and formalized mechanisms of international law. The increasingly dense network of international organizations of various kinds and powers, as well as the proliferation of treaties and international arrangements and agreements covering thousands of matters major and minor, have grown in the last 30 years both to express and to mask the increasing powerlessness of the dominated peoples of the world. However, in many ways, the problem of jurisdiction is more clearly symptomatic of the crisis of international law and of the international system. The principle of territoriality of jurisdiction is the cornerstone of the international system based on the nation-state. The transition from the personal sovereign to the abstract sovereignty of public authorities over a defined territory was a key element in the development of the capitalist international system, since it provided a multifarious framework which permitted and facilitated the global circulation of commodities and capital. The independent and equal sovereign nation-state is therefore a fetishized form of appearance, and the independent and equal sovereign nation-state is therefore a fetishized form of appearance. For the world system is not made up of an aggregation of compartmentalized units, but is rather a single system in which state power is allocated between territorial entities. This is important since exclusive jurisdiction is impossible to define, so that in practice there is a network of overlapping and interlocking jurisdictions. With the increasing international integration of capitalist social relations, the extent of overlap and potential conflict becomes greater. While Marxist economics has generally been more apt to grasp and analyze capital as a global phenomenon than have bourgeois economists who tend to focus on the national economy, there has been a tendency for Marxist analysis of the capitalist state to focus on the state, the individual state. This is perhaps a greater tendency in Marxist than in non-Marxist writings, since the Marxist emphasis on the class nature of the state makes it necessary to discuss the state in relation to the structure of society, and it becomes convenient to assume a correlation between the society and the classes within it, and the state within that society. However, the Marxist state theory that emerged in the late 70s had one of its strengths, the possibility of a different approach based on its different starting point, which was class relations seen as formed by the process of capital accumulation. SImon Clarke, in his seminal critique of Poulantzas, rightly emphasized the dangers of interposing between the relations of production and the state a realm of, quote, civil society, end quote, composed of ideological and institutional relations, which is no more than the sphere of interacting social groups of bourgeois sociology. The starting point for state theory should not be, quote, society, end quote, but class relations dominated by the relations of production and processes of capital accumulation. The political importance for Marxists of combining an analysis of capital accumulation as a global process with an international perspective on classes and the international state system has been re-emphasized recently, e.g. by Radis's critique of Aglietta and Van der Pijl's important analysis of international class formation. The historical development of the international state system. As I have stressed, seen from the viewpoint of the capital relation, it is clearly wrong to think of the capitalist world system as an aggregation of individual societies and their states. Both logically and historically, the first moment of the capitalist state is the establishment and maintenance of generalized commodity production. Thus, the capitalist state originated as an international system of states establishing a framework for the increasing generalization of commodity production initially on petty commodity production and the world market. However, as Brenner pointed out in his critique of Wallerstein in 1977, it is important to avoid what seems to be Wallerstein's mistake I think it's Wallerstein. Wallerstein's mistake in attributing a determinate role to the market and the international division of labor. In Wallerstein's schema, it was the world market and the consequent international division of labor that allocated a particular role to each region, from which flowed the relationship of exploitation and hence the form of state. Brenner emphasizes that it was not trade that transformed production relations, but the contradictions of feudal and post-feudal production relations that led to transformations both of the world market and of the form of state. Thus, in taking a global perspective, it is not necessary to start from the market. It is both possible and necessary to start from relations of production and exploitation and how they interact internationally through circulation. Again, Brenner emphasizes that the origins of imperialist underdevelopment of the periphery must be sought not in the, quote, unequal exchange, end quote, of raw materials for manufactured goods, but in the class character of production relations in the periphery, where the extension of absolute surplus labor based on forced labor contradicted the need to improve profitability through developing the productive forces by investments in fixed capital and improvement of skills. Historically, the development of the notion of the sovereign state with exclusive powers within its own territory and unable to exercise jurisdiction within the territory of others was also strongly influenced by ideas embodying an overriding universality of law. The classical international jurist, notably Grotius, saw state sovereignty as defined and limited by natural law, divine law, and the Roman law-based notion of the jus gentium, law of the peoples. Recent legal writers and international relations theorists have pointed out that this Grotian view of national sovereignty entailed a duty to honor and assist in the enforcement of a valid regulation of another state, the doctrine of, quote, comity, end quote, which some now argue should be revived in a new form. This was not in accordance with absolutist versions of national sovereignty, however, and was eventually eclipsed by 19th century positivism. In its naive version, e.g. Bentham, positivism holds that since there is no sovereign before the state, there can be no international law. More sophisticated versions accepted that reciprocity and mutual agreement provide the basis for obligation in international law. However, this is still open to the voluntarist interpretation which found expression in the famous International Court judgment in the Lotus case of 1927, which held that since rules of international law emanate from the free will of independent states, no restriction by denial of a claim of jurisdiction over acts taking place abroad was possible unless based on explicit agreement or a universally accepted general rule. Positivist definitions of state sovereignty and jurisdiction are more or less adequate for liberal forms of regulation, since they can rely on the separation of public and private regulation and the separation of prescription and enforcement, which characterize such liberal forms. Under the liberal international state system, it is open to the state to prescribe rules even beyond its territory, and specifically to apply them to its nationals wherever they may be. Equally, individual economic persons can be afforded a very broad freedom to determine for themselves the legal framework that may apply to their transactions. In the end, however, public, especially penal regulation, as well as the exercise of the state's power to enforce through investigation or through sanctioning, must be territorially defined. Nevertheless, it is possible, through interstate arrangements based on reciprocity, to coordinate and mutually reinforce the national enforcement powers of states. Thus, from the late 19th century, there was a growth both of a network of bilateral arrangements for the mutual support of national jurisdiction, e.g. extradition, as well as of specific functional multinational organizations for the coordination of state functions, e.g., the Universal Postal Union. This liberal international state system comes under increasing pressure during the 20th century, both from the increasing international interdependence, especially of economic activity, and from the transcending of liberal forms of state regulation to more direct interventionism in which there is less separation of the public and the private, e.g. the growth of economic, quote, regulatory, end quote, law, such as antitrust trading law, provision of technical standards, etc., and less separation between the prescription and the enforcement of rules, e.g., enforcement is not left to private parties if their economic interests are damaged, but entrusted to public authorities which require direct compliance by notification, registration, approval before action. Thus, jurisdiction becomes less, quote, open, end quote, with the freedom to choose a desired form for dispute resolution, subject to the application by it of rules to determine the, quote, proper law, end quote, of the dispute, and subject to the final power to enforce within a state where assets can be found and the state accepts the adjudication as valid. The adjudication by one state is more likely to conflict directly or indirectly either with private rights or with public regulation in another. At the same time, as I have pointed out above, increasing international economic and social integration creates an increasing overlap of jurisdictions. Not only does it mean that more than one state is likely to be involved in an activity, typically within a MNC, I guess that's multinational corporation, although the ramifications of international capital are not necessarily confined to the internal workings of individual capitals. It may also makes it easier for a state interest in jurisdiction to be made effective. One second. Okay, I'm not exactly sure where I left off, but at the same time, as I have pointed out above, increasing international economic and social integration creates an increasing overlap of jurisdictions. Not only does it mean that more than one state is likely to be involved in an activity, typically within a multinational corporation, although the ramifications of international capital are not necessarily confined to the internal workings of individual capitals. It also makes it easier for a state interest in jurisdiction to be made effective through actual control within the territory of some person or property connected with the activity. Thus, a multinational corporation can be fined through a subsidiary or permanent establishment in a country, even in respect of actions which it claims took place elsewhere. Conversely, it is of course possible for a multinational corporation to arrange for particular actions such as the signing of a contract, the location of documents and records, or the meeting of a board of directors to take place wherever it might be convenient. This increasing difficulty of defining national jurisdiction has led to diverse attempts to redefinition and conflicts over their effects. The U.S. authorities have been in the forefront of the redefinition of jurisdictional competence to apply not merely to acts taking place within the territory and nationals wherever nationals may be, but to activities having direct, substantial, and foreseeable, quote, effects, end quote, within the territory. The British government has been in the forefront of resistance to this redefinition, although other regulatory bodies, such as the European Commission, especially its Competition Directorate, have themselves adopted the quote, effects, end quote, doctrine. It has also been pointed out that whether or not a quote, effects, end quote, doctrine is accepted, the physical notion of territoriality which the British are attempting to maintain is increasingly unworkable. International financial and economic transactions cannot easily be defined as, quote, taking place, end quote, within any specific territory. As a consequence, international lawyers have called for radical measures, either, quote, a refinement of the concept of sovereignty in international law so that it can accommodate both notions of interdependence of states and of the increasing both, quote, either quote, a refinement of the concept of sovereignty in international law so that it can accommodate both notions of interdependence of states and of the increasing interdependence of states without losing its coherence as a legal principle, end quote. Lo, or the total abandonment of sovereignty as an inappropriate starting point based on, quote, vertical rather than, quote, horizontal thinking. The increasing tensions and conflicts of the international state system have gone together with both internationalization of class conflicts and internationalized class alliances. However, this internationalization of class relations must take place within new international legal and state forms which can help to structure the political relations involved. These have been notably slow to develop. New international state forms. As mentioned above, the post-war period has seen the rapid development of a bewildering variety of international arrangements between states, ranging from multilateral organizations, both within and outside the UN system, all sorts of treaty arrangements, but also an increasing variety of informal interstate bodies and arrangements. Many of these informal arrangements have much greater importance and power than the formal and visible organizations that are thought of as the international system. For example, economists are familiar with the OECD, which, though it lacks the explicit functions and powers of, say, the International Monetary Fund, in many ways plays a much greater role in attempting to generate the coordination between state officials that is vital in an increasingly integrated capitalist world. Equally, bodies such as the Trilateral Commission, although their importance can be exaggerated in left-wing mythology, clearly play an important role in attempting to generate a transnational capitalist ideological consensus. The conflicts over application of technological embargoes have brought to public attention the whole of COCOM, an informal committee of officials operating by consensus which, although never entirely effective, plays an important role in coordinating the capitalist states' policies on technological and economic embargoes of the Soviet bloc. These informal and kaleidoscopic arrangements are far from the smooth and inevitable process of coordination of international state functions envisaged by Warren and even posed by Murray as one of the possible alternatives. To take, for example, international arrangements to, quote, chain down the euro-dollar monster, end quote. Although it has clearly proved a vital aspect of the process of economic internationalization, and a faithful ally of the multinational corporations, the failure to establish any effective regulation of the eurodollar is blatant, although in the wake of the Ambrosiano bank collapse, the central bankers agreed to revise the informal Basel Accord in order to agree on an allocation of responsibility for oversight of international financial institutions. There was a failure to agree on allocation of lender of last resort responsibility. I can also give a more extended account of the problems of national tax authorities in, quote, getting control of the internal transfer price problem, end quote. As Robin Murray's own subsequent research revealed, the national tax authorities have had increasing difficulty in their attempts to, quote, reclaim the market, end quote, by applying the arm's length formula to non-market exchanges by international capitals. On a national level, there have been great struggles in securing the resources to set up units of national officials to give anything like adequate scrutiny to transfer pricing problems. In the UK, for example, apart from oil taxation and the district tax offices in the city, which handle international bank transactions, all transfer pricing problems by the multinational corporations operating in the UK are scrutinized by a central unit consisting of only 7 people, of whom only one is an accountant. They rely largely on informal negotiations, especially with the handful of major accounting firms who advise the multinational corporations, keeping their legal powers and sanctions in reserve, e.g., the power to direct an adjustment to a non-arm's length transfer price has hardly ever been used and has never been legally challenged. They reckon to have, quote, saved, end quote, a total of $200 million by adjustments to company profits made as a result of this informal process. So far, the international arrangement for coordination of taxation of multinational corporations have been largely limited to agreements between tax authorities to exchange information. A pioneering arrangement was established between the UK and the US in 1978, providing for the, quote, simultaneous examination, end quote, of a multinational corporation. Although this is under secret and informal agreement, it is subject to a fairly tight bureaucratic, quote, Although this is under secret and informal agreement, it is subject to a fairly tight bureaucratic political control and has been used for fewer than 100 cases since 1978. The OECD has attempted to develop coordination between tax officials and agreement on questions such as the treatment of fixed costs. These international bodies have remained firmly opposed to the, quote, unitary or, quote, formula apportionment, end quote, approach to taxation, which has been strongly fought by the multinational corporations. Although this would pose the political problem of agreement on the criteria for the, quote, formula, end quote, on which apportionment should be based, in principle it provides a more rational approach to national taxation of internationally integrated economic activities. I use these examples to show that there is by no means a sharp alternative between the total breakdown of international state arrangements on the one hand, or the development of adequately functional global forms of regulation on the other. On the contrary, what we see are ramshackle attempts to patch up the international state system by ad hoc arrangements of the most informal kind. This informality responds also to the internal development of capitalist state forms, in which the open, public, regular, rational, universally applicable, and autonomous state forms of liberal ideology have, to the extent that they have ever existed, been transcended by more direct, interventionist, secretive, bureaucratic forms. These may be characterized as, quote, corporatist, end quote, not in the sense of tripartite state institutions, nor in the sense that the state apparatus is supinely accepting or carrying out the dictates of corporate capital, but in the sense that the attempts to regulate capital in general takes place through direct negotiation between state officials and corporate managers. I have also focused on those aspects of the state that are concerned with the regulation of capital in general rather than labor and its exploitation. In this context, also, similar contradictions can be shown, e.g., in the attempt to coordinate employee representation structures and information requirements through the Fifth Company Law Directive and the Rettling Directive of the EEC. Nevertheless, I think it important to emphasize the existence of a contradictory process of internationalization of capitalist regulation, since it is sometimes said that internationalization is unproblematic, end quote, for capital, end quote, whereas it poses grave problems of international organization, quote, for labor, end quote. While I in no way underestimate the problems for the working class movement to organize internationally as well as nationally, I think it important to emphasize that, quote, capital, end quote, is a social relation, and if there are contradictions in the process of internationalization, they are contradictions for those on both sides of the relation.